and welcome back to Legalese 123. Today is Thursday. Oh my goodness, November is already flying by. It's the 6th of November. I hope you're doing well. So, what are we going to talk about today? Did you guys see that full moon last night? Whew, it was super pretty. Wow. I don't know if anybody's uh, bodies and stuff are out of fluctuation with that full moon, but it was beautiful. The weather's been nice as well. Hopefully, we have a mild winter. So, hope everybody's doing well. Glad to see that you're back. What are we going to talk about today? Well, this is a very personal case to me. As some of you may know, we lived in Moscow, Idaho before the murders happened and moved. And unfortunately, it has devastated friends and family within the community. Moscow is a beautiful town. It is very sad for the victims and the families that this occurred. It was a very small and quiet town. And again, not exactly sure how or why the perpetrator chose this location. It might be something that we'll never find out. We don't know if it was necessarily the victims or if it was the house, but he was a criminology student at WSU, and he wanted to commit the perfect crime. Unfortunately, he wasn't successful. He did commit the crime, but he wasn't successful in getting away with it. So let's talk a little bit about, if you're not familiar with the case, we will go back and do a deep dive. Currently, right now, the courts will be going on a little bit of a hiatus because of the holiday schedule. So we'll have some more time to go back and deep dive into some of these cases. This is one of them that we will go ahead and give a little bit more context. But for right now, we're talking about the University of Idaho 4 murders. It's sad. The victims were Kaylee Gonzalez, Madison Mogan, Zaina Kernodle, Ethan Chapin. They all lived in an off-campus apartment at the University of Idaho. Kaylee and Maddie were really good friends, lifelong friends since middle school. And Ethan and Xana were boyfriend and girlfriend. They had a wonderful day out. I think they had gone to a game. They were celebrating with friends. Even Xana's dad had come to visit her. Her sister went to WSU. Ethan spent some time, he's a triplet, spent some time with his brother and sister at a party at one of the fraternities or sororities. I'm not sure exactly which one. And they all had, a good night out, unaware that things were going to come to a tragic ending. So the person who perpetrated these crimes is Brian Kohberger. He was charged and pled guilty to the murders after receiving 4 consecutive life sentences. When the crimes were committed, there was some information that was given out, which was that a knife sheath was left behind. It was tucked near Madison Mogan, and it had touched DNA on it. It is a controversial subject, which is that how they discovered that it was related to him was done via IgG, which is called investigative genetic genealogy. What that means is that they sent a profile of his DNA through the DNA websites of relatives that were on the Kohberger side and slowly connected it to his family. They got a search warrant for dad. They actually got a search warrant for their trash, went through their trash and found that it was linked to the dad. And then eventually when he was arrested, they took his DNA and matched it to him. In the beginning, he claimed that he didn't do it and he was very innocent and he needed his day in court. And the beginning onset of this case, the reason why it's so controversial is that limited information was being said about the case and how they connected it to him. There was a gag order on the case from the beginning, and so therefore the police were unable to give any closure to the families. And it wasn't until a trial was going to happen that they would have gotten some answers. possibly through Brian Kohberger and or his attorneys, they kept filing different types of motions and suits to obviously discredit the evidence that was going to be presented against him in court, which is what every lawyer should do to advocate for their client. Some might feel that the frivolous motions that were being presented in front of Judge in Moscow, Idaho, were a little bit out there. But if you're a law nerd, like I am, it was great fodder, right? So when you go to court, it is a battle. It's a theatrical battle between the defense and the prosecution. And there are some great legal arguments that were made, going back to the Magna Carta and was he given a fair assessment when it was sent to the grand jury? Anyways, we'll deep dive into that later when we go through his case. They did make some great legal arguments and it was great legal fodder. But if you are a family member and you are interested in knowing how and what happened to your children, it wasn't great fodder for them. They wanted answers. So unfortunately, the case then got a change of venue. It was moved from Moscow, Idaho to Ada County in Boise, Idaho. And they got a new judge. And the new judge was a no-nonsense judge, Judge Hippler. Really like him and how he handles his courtroom. They were set to go to trial on August 4th. Jury selection was set to begin. But unfortunately, Kohberger may have realized that his time was up. He had no motions to file and that the evidence against him was surmountable and that eventually was going to come out in court and eventually he probably would have been convicted. But he ended up pleading guilty because the death penalty was being set forth in his trial. The Idaho legislature actually reinstated death by firing squad in the case if Mr. Kohberger was convicted and was given the death penalty. So he ended up pleading on July 2nd, and the death penalty was taken off of the table, and he then got 4 consecutive life sentences, plus I believe 10 for the burglary charge. So why are we bringing him up today? You know, he pled, he's in jail, he's, going to be there forever. Probably he's got no possibility of parole. Why are we even bringing him back up? Well, he filed a motion regarding his resentment over paying restitution to the victims. So what is restitution? Restitution is a court-ordered payment from a convicted person to a crime to cover financial losses caused by the crime. Lost wages, medical expenses, property damage, counseling, whatever it is to make the victims whole for the crimes that the person who was convicted committed. Economic losses, repair, replacement for property damage, and other direct costs that are necessary, again, to make the person whole. So, do you think that Kohberger should have to pay for restitution? Let me know in the comments below. So the defense filed a motion stating that they didn't want to pay for the restitution. So let's read and see what they have to say. So comes now Brian Kohberger through his attorneys of record and hereby objects to the state's request for additional restitution. Filed on September 22nd. The grounds for the objection are that the plea agreement specified funeral expenses and funds reimbursed through Idaho's Crime Victim Compensation Fund in the amount to be determined. So from July 23rd, Mr. Kohberger stipulated to the amounts, resulting in court orders in the amount of $28,000 approximately on August 29th. The additional funds sought did not qualify as an economic loss under Idaho Code 19-5304. Steve and Christy Gonzalez and Karen Laramie. Steve and Christy are Kaylee's mom and dad, and Karen Laramie is Maddie's mother. Received extensive funds through multiple GoFundMe campaigns that specifically asked for and covered the expenses sought. Mr. Kohberger has the ability now, or does not have the ability now, nor in the future, to pay restitution because he is serving 4 consecutive life sentences plus 10 years. A judgment was entered against Mr. Kohberger on July 23rd. The plea agreement stated that the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in the amount to be determined. The judge the judgment of the conviction ordered around $251,000 in criminal fines and fees, $20,000 in civil judgment for each of the families named in the indictment, and also directed the state to notice restitution for hearing if parties cannot stipulate to the amount within 60 days. With respect to the Crime Victims Compensation Program and funeral expenses, the parties stipulated on August 27th to around approximately $28,000, and corresponding were entered on August 28th. On September 22nd, the state filed its state's request for restitution and a motion to seal exhibits, seeking an additional $20,000 for Christy and Steve and around $7,000 for Karen Laramie. An itemized statement with receipts was attached attached and under seal. No documentation showing reimbursement from the Crime Victims Compensation Fund was included. The receipts related to travel and accommodation. In the plea agreement, it is ambiguous about the restitution categories Mr. Kohberger agreed to pay, and once receipts and verification were provided. He stipulated accordingly, this court must consider contractual terms that are expressly provided in the legal plea agreement, as well as the contractual terms are implied, citing State v. Doe. Given the express language in the plea agreement, the only additional receipts submitted that may fall within the contractual terms are those for the urns. The urns. Oh my goodness, let me tell you about the urns. They are so precious. So after everything was settled, the families then decided to go ahead and get urns for Kaylee and Maddie. Again, Kaylee and Maddie were very long-term friends since middle school. And it's so sad that their lives were ended together. And so the families purchased these beautiful urns, and they decided to do this after the case was settled, and rightfully so. I mean, it's their choice to do with what they want with the remains of the girls. So it was after stipulated fines and stuff were given to Kohberger's defense. So should he have to pay for it? I say yes. Anyways, that's my opinion. So let's continue on. So in section code 19-5304 defines economic loss as economic loss includes, but not limited to, the value of property taken, destroyed, broken, or harmed, lost wages, and direct out-of-pocket losses or expenses such as medical expenses resulting for the criminal conduct, but does not include less tangible damage such as pain and suffering, wrongful death, and emotional distress. Several GoFundMe campaigns resulted in funds raised for the Gonzalez and Laramie families. Specifically, one GoFundMe campaign for Madison and Kaylee raised $73,000. These funds were promoted as going to the families. So yeah, they had GoFundMes because they were going to have a lot of expenses. Kaylee's family and Maddie's family are not from the Boise area. So they were going to have to find a place to live in Boise to attend the trial. The trial was going to be around 6 to 8 weeks, maybe even longer. So they needed a place to stay. They needed to have expenses for travel. They needed expenses for living and eating, etc. So they had several GoFundMes for that. And when they realized that there was a plea agreement and they weren't going to utilize all of those expenses, they were working out how to refund people who had donated to them. Another GoFundMe campaign for Karen Laramie raised around $48,000 to help Maddie's family attend the Idaho trial. And as clarified, the funds were in fact used to travel to Boise for the hearings, including the sentencing hearing. A third GoFundMe campaign for Steve and Christy raised around $85,000 for the purpose of attending court hearings in Boise after the venue was changed. So, given the specific funds sought and obtained for expenses to travel to Boise, the request should be denied because neither family suffered an economic loss for which the state seeks reimbursement. Both families did indicate a desire to refund any donations after the case was resolved after the sentencing, but whether they were able to accomplish this or donors requested funds returned is not included in the state's motion, nor should it be, FYI. All right, so the Idaho Code Section 19-5304 provides guidance in determining whether restitution would be appropriate and states that the court should consider the amount of economic loss sustained by the victims as a result of the offense, the financial resources, and need and earning ability of the defendant. Let's pause there for a moment on that. The need and earning ability of the defendant. We'll circle back to that. And other factors as the court deems appropriate. Economic loss is addressed above in the light of the GoFundMe donations. The specific funds for which the Gonzalez and the Laramie families seek reimbursement travel to Boise. There is no sustained economic loss. Additionally, Mr. Kohberger has no ability to earn money or pay given his 4 consecutive life sentences plus 10 years. Unlike other cases where the Idaho courts have ordered restitution for short and long-term prison sentences, Mr. Kohberger is different. How is he different? He'll never have the ability to pay restitution, and even though he stipulated to restitution amounts, there is no foreseeable ability for him to even make payment. So under the Idaho law, he'll never be able to profit by way of book or movie or entertainment of any kind. Really? So for all the reasons stated above, Mr. Kohberger objects to the request for additional restitution, and he waives his own attendance of the hearing in this matter and requests that he not be transported because his defense counsel will be there. All right. So when the defense files a motion, the state gets to file their response. So let's see what the state had to say. So come now, the state of Idaho, by and through the Latah County prosecuting attorney, and respectfully responds to the defendant's objection to the state's request for additional restitution filed on October 7th. The state acknowledges the Rule 11 plea agreement filed herein. Regarding restitution under Section 4, the agreement states the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in the amount to be determined at the time the plea agreement. This state was under the impression that certain expenses incurred by the victim's family would be covered by the crime victims' compensation. After the sentencing hearing, the state was informed that the crime victims' compensation will not cover travel and lodging expenses for attendance to court proceedings. On behalf of the victims, the state submits the itemization of expenses that were incurred by the victims' families, including expenses not covered by the crime victims' compensation, for the court's consideration. The state is affirmatively advocating for payment of funeral expenses as itemized by State's Exhibit 2 pursuant to the plea agreement. The defendant argues that the request for restitution should not qualify as direct economic loss since the victims' families received third-party donations. Under the Idaho Code 19-5304 and controlling precedent, directly injured victims may receive full restitution despite third-party payments, unless those third parties qualify as statutory victims through contractual obligations to pay. State v. Cheney. Applying the Cheney analysis to this one, charitable donations such as those received through the GoFundMe arise from voluntary generosity rather than legal obligations. Since charitable donors lack contractual obligations to pay victims, they cannot qualify as statutory victims under the Idaho Code. Therefore, their payments do not reduce the defendant's restitution obligation to the directly injured victims. This is also supported by public policy consideration focusing on making the victims of the crime whole for defendants' criminal conduct rather than accounting for victims' good fortune and receiving community support. State v. Schultz. Lastly, the defendant argues that the restitution should not be awarded based on defendant's ability to earn money or pay, given his 4 consecutive life sentences plus 10 years. Defendant's objection provides clear authority in courts to order restitution from life sentences defendants. The statute mandates that the courts shall order a defendant found guilty of any crime which results in economic loss to a victim to make restitution to the victim unless the court determines restitution would be inappropriate or undesirable. The immediate inability to pay restitution shall not be, and in itself, a reason to deny restitution. While Idaho law permits restitution orders for life sentence defendants, courts retain discretion to determine whether restitution is appropriate in individual cases. This discretion enables courts to consider the specific circumstances of life sentence cases, including the defendant's age, health, and realistic earning potential. And in this case, there is a history of this defendant receiving financial compensation from family and third parties. Ooh, how does that happen? Well, as some of you may know, there is a thing called commissary. That means that people can give money to a fund through the government that will allow Mr. Kohberger and other criminals to get special things in jail. They can get food items. They might get socks. I'm not exactly sure what's on the list, but they can get special things outside of their normal things that are provided to them from the state. So his family and third parties, other people out there in the world, have been paying for his commissary. So, where was I? By way of example, the state is attaching a summary of the financial contributions made to the defendant while he was in custody at the Ada County Jail and the Latah County Jail. In the event that the defendant is able to obtain financial compensation from third parties or his family, the victims should have ready access to these assets for the satisfaction of their losses. Additionally, this case has and will continue to attract worldwide attention, which could result in the defendant prospectively receiving monies subject to inception by the state treasurer pursuant to 19-5301. Restitution orders may be recorded as civil judgments under 19-5305 and should be collected from any monies prospectively deposited in escrow with the state treasurer. So based on the above, the state hereby amends the state's request for restitution filed on September 22nd, seeking outstanding funeral-related expenses per Rule 11 plea agreement, and simply submits that the balance of the victim's requests for the court's consideration. So in doing so, the court then, the prosecution, the state, requested a motion hearing. And we're going to go ahead and see if we can find that. And we are then going to watch it together. So we'll see if we can go ahead and get this on. Oh, here we go. Let's see. Oh. Hold 1 second, please. All right, here we go. So buckle up because we're going to go ahead and play this for you right now. Oh, those flipping pages are a little loud there, Judge Hippler. Might have to turn the volume down a little bit. All right, let's go.
All right, let's go on the record in State v. Kohberger, CR 0124316665. The defendant has been excused from today's proceedings. It is not present. The defense is represented by Ms. Massoff, Ms. Taylor, and Ms. Barlow. The state is represented by Mr. Thompson. This is a time set for a hearing on the state's supplemental request for restitution. The state can argue first.
Thank you, Your Honor. The attached documentation, it doesn't appear that there's a question about the amounts. I think the question that has been raised is whether the propriety of any additional restitution being ordered at this point. Yesterday afternoon, we did receive a supplemental filing from the defense, and I want to respond to that just for the record before I address the merits of the restitution requests themselves. As we indicated in our response to the defense objection to the additional restitution request, at the time that we entered into the plea agreement, Ms. Jennings and I were under the impression that crime victims' compensation could be available to cover reimbursement of travel expenses. And I have to clarify that now. It is true that before trial, the families approached our office asking if there were any resources we were available to pay in advance for travel expenses or expenses related to them attending trial itself. And we looked into that, our staff looked into that, and advised them no. It was my understanding, and I'm mistaken, I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that crime victims' compensation could be available to reimburse expenses like that. I now know that's not correct, and it was certainly my mistake. I will own it as far as our state of mind going into the plea agreement. So that being said,
go ahead.
I'm sorry.
Go ahead. I'll let you finish the point on the plea agreement, and then I have a question for you about that.
And I was just finishing that point, Your Honor, so this would be a good time.
Okay. So it's pretty well settled that plea agreements are interpreted as contracts, which they are. I think it's pretty well settled contract law that a unilateral mistake does not relieve one of its contractual obligations and restrictions. So how can I how can I order this restitution if the express terms of the plea agreement, though mistaken understanding by the state, don't allow such extra crime victims compensation fund reimbursement?
And Your Honor, I recognize that, and that's what I was just getting ready to address. In response to the defense's objection, the state has modified or adjusted our position on the restitution. We are, pursuant to the plea agreement, seeking restitution for the funeral-related expenses, which are the urns that are described in Exhibit 2 to our response. We are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. At the same time, the families provided those to us, and we want to provide them to the court and counsel just so everybody was aware that they are there, but we are not arguing affirmatively for that because of the wording of the plea agreement itself. So what the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the urns for the families.
Okay, thank you. And you can address the other issues as well.
I'm sorry, Your Honor, which other issues?
Well, the issues, if you'd like, raised in opposition to your motion, including the lack of ability to pay by a defendant and et cetera.
Yes, thank you, Your Honor. I apologize. The defendant has raised the issue of his alleged inability to pay, and we recognize that he's going to be incarcerated until he dies. But that in and of itself doesn't mean that over the course of the balance of his life, he might become, he might receive assets. And in fact, we attached a breakdown of the types of monies that he has received during his incarceration. We also noted the statute that allows the treasurer to intercept prospective monies that might be received based on any attempted publication of the story of the defendant. And those, if received, would be something that a restitution order could be enforced against. We also know.
So I pause it here for just a quick second. The Latah County prosecutor, Mr. Thompson, we AKA call him Santa, just said publications. So what does that mean? Is there a Son of Sam law in Idaho? So I don't think so. So let's listen a little bit more clearly and find out what he means by that.
The language of the statute and the case law interpreting the restitution statute, which is 1953-04, if I believe off the top of my head, talks about current inability to pay is not necessarily a block to the order of restitution. It's just merely a factor for the court to consider. And it is our position, given the relative youth of the defendant, the fact that he has been receiving significant monies during his incarceration already, and that there is the possibility of future monies, whether by virtue of the statute with the treasurer impounding proceeds from a story related to this, or perhaps from an inheritance from his family or others. We can't see into the future. We don't have a perfect crystal ball. The state's position is having this additional restitution place.
Well, that's interesting. If you receive an inheritance within your family, if monies are to be given to you, Mr. Kohberger is fairly young. He's only around 28, 29 years old. So he does have a long life in prison. So eventually could those monies then be funneled to the families? Let's keep listening.
Which is really fairly minimal, would be appropriate and have them available that if the defendant comes into assets, that the families would be able to try to satisfy the restitution orders from them.
Thank you. And then who's arguing for defense?
I will be, Your Honor.
All right.
Thank you. Given that the state has clarified its position that it's only seeking reimbursement for the urns, it's my understanding that that amount is $1,420 for one family, $1,587.79, and then another $167.79, which would be a total, I believe, if my math is right, of $3,075.58. My understanding of reading the Victims Compensation Code 1953-04 is that the court must still do an analysis on Mr. Kohberger's ability to pay. And as the state has addressed, we are arguing that he does not have an ability to pay. While there have been lump sums provided to you regarding some funds that he received prior to his plea agreement, what the court does not have is a breakdown of how those funds came into the inmate system for his expenses and the fact that they were primarily family. Certainly his situation pre-plea and sentencing was drastically different than it is right now in terms of money that is available to him. And there's nothing in the record to provide the court with anything other than what is really speculation based on the past, as opposed to something that the court might be able to rely upon about foreseeability. There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book because Idaho Code 1953-01 specifically precludes that.
Well,
and
it allows that monies are swept from his account for those income to pay certain things. If those certain things, if there's no debt for those certain things, then does the money not go then to the defendant?
that is not my reading of the code. Perhaps I'm reading that statute more broadly than the court is. I understood it to be that the purpose is that someone can't then profit off of their crime pursuant to that statute. I guess I need to read it with that broad
even allowing
implication.
even allowing your reading of it, what's to prevent, for example, a family member from agreeing to, provide information, be a part of, et cetera, a story, movie, book, whatever, TV series about the murders, about Mr. Kohberger, and that certainly wouldn't be monies they receive wouldn't be subject to the statute, and then they certainly would be free to send Mr. Kohberger money to his account.
Exactly. That's exactly what I was thinking. If his family wrote a story based upon all of his actions, et cetera, and they profited from it, he couldn't profit from it because there's sort of a son of Sam law in Idaho. We'll go back to what that actually means. It's not exactly called the son of Sam, but that's kind of what it says, that you can't profit off of your own crime, but his family can. And then his family then gives him money via commissary. So let's see what the judge has to say in reference to that.
What harm is it to order the restitution, which would then sort of jump in line in terms of priority of payments over some of the other ordered payments, such that if Mr. Kohberger does receive money into his accounts from any source, that he's then that those monies are then put to that use. Certainly, we're not worried about Mr. Kohberger's credit rating with having debts at this point. I'm not sure what the concern would be to, given the uniqueness of this case and the potential for family members, et cetera, to earn money from it, and potentially we've seen members of the public send money to Mr. Kohberger.
Oh, and by the way, I forgot to mention that it is purported that his sister Melissa may have already written a book about things. So it may be something that's already in the works.
Here's my understanding to his books. What's the downside to ensuring that the victims are as whole as possible from this by ordering the restitution, which again would jump in line from some of the other court-ordered fines, et cetera. And if the money's there, it's there. If it's not, it's not.
Judge, I don't see that Idaho code or Idaho law asks the court to make an analysis on the downside, but whether or not there is foreseeability of payment. And all of the things that you just listed are pure speculation. There is no book or movie that's in the works by any of his family, and to say that those things are going to happen is absolutely speculative, and there's nothing to substantiate those sorts of assertions happening in the future. So
well, there's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books.
What? Wait. Let's, oh my goodness, we have to go back. Wait, what did he just say?
Substantiate those sorts of assertions happening in the future. So
well, there's a history in the 3 years he was incarcerated of him receiving 5 figures put on his book. 5 figures.
Wait, what? 5 figures are being put on his book? That is more than half of America makes. And he's just sitting in jail for killing 4 people. Really? 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 And we're fighting over urns. You've got to be kidding me. Oh my goodness. Wow. And that's just in the time frame that he was incarcerated in jail. So we're talking just like 3 years. He's going to be in jail for many, many, many more years. I mean, he's almost 30, right? If he lives to 70, that's 40 more years. Oh my goodness. Oh, let's see how this plays out.
Doesn't that give the court some history to suggest that such contributions from whatever source may continue into the future?
As I stated earlier, Judge, that was at a different time in the case. That was at a time when, he had not entered a plea. He was not deemed convicted of the crime. The money, a lot of that money was coming from his family to be able to have communications with their son and brother. And to speculate that those kinds of dollars are going to be able to happen for the next many decades is exactly that. It's pure speculation.
Wait a second. Is she claiming that the money from the family, 5 figures, is money for him to call them? Does it really cost hundreds of thousands of dollars for his family to communicate with him? How much does it cost for a jail call? Huh.
Not based on something that is foreseeable or based in something that's in fact before this court.
Well, it just seems to me that one of the, really, obviously, even application of statute requires the court to look at what might happen into the future. And I guess, it seems to me one of the best indicators of the future is the past. And in the past, his family has.
Exactly. So in the past, he's been receiving money, and who's to say it's not going to happen in the future?
You're saying the family was the source of much of these funds, has provided him funds in order for him to communicate, et cetera. That necessity will still exist going forward. I'm not aware of his family having disowned him at this point and not wanting any contact with him. And even if they are, that doesn't mean that won't change. And you call it speculation. It seems to me that it is good evidence of what may occur in the future in light of what has occurred in the past.
Exactly.
Well, Judge, there is a judgment against him in the amount of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000. Another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that other factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which definitely reimburse the cost of the urns in terms of economic costs.
I also want to turn to the plea agreement, because isn't a reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the.
Exactly. Part of the plea agreement was that he can't complain or come back and say anything. He can't appeal. He can't appeal anything that was part of the plea agreement. So is he appealing the decision? Not necessarily the decision, but is he appealing restitution, the agreement that they had? Great question, Judge.
Plea agreement. Otherwise, why would it need to be in the plea agreement?
Exactly.
It seems to me it's the plea agreement. A reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation, which includes in this case funeral expenses.
Exactly.
So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty, why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Exactly.
Judge, I believe that our pleading was clear, that we understood that urns fell underneath a funeral cost, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis. And that's why.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
Exactly.
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
Exactly.
Judge, again, in our pleading, we objected to what the state has withdrawn as of this moment at this hearing today.
Right.
We acknowledge that the urns were funeral expenses.
Right.
But once we're in this situation of having a hearing, then this other section about whether or not he has an ability to pay is triggered. We stipulated to $28,000 in restitution within 60 days.
Right.
He met the terms of the plea agreement.
But it also says the state may seek restitution regarding funeral expenses, and they're simply identifying additional funeral expenses.
Exactly.
I don't know what more you want me to say about the urns other than
what's the point of the plea agreement if you're not going to be bound by it?
I agreed that it was $3,075.58.
But you say you shouldn't have to pay it.
Right.
What I said was that the court needs to do the analysis under Idaho code about his ability to pay.
Why hasn't the defendant waived his right to rely on that ability to pay by agreeing to those expenses as part of the plea agreement?
Exactly.
I don't know how the court can enter this order today without engaging in the analysis under Idaho code because it's required. That's the way I review the case law and the code, that once there's a hearing about restitution, then the court has to engage in the analysis on the ability to pay.
So the agreement to pay is illusory.
Exactly.
No, we agreed to $28,000. We've agreed that the urns fall underneath.
Does he have the ability to pay that?
No, he does not have the ability.
So why did you agree to it?
Because it was a specific, we were provided with.
Oh my gosh. Whoa, this judge. Again, remember I told you Judge Hippler is no nonsense. It's fabulous. He's just not going to take this argument. Unfortunately, she's just not making clarifications set that weren't in the agreement. And she can argue up and down of what her interpretation is, but he's oh boy, he's gonna rule in the state's favor.
Those receipts within 60 days. We were not provided with the receipt for the urns within 60 days.
So is your objection
oh boo-hoo. Oh no, Judge, we only said these 60 days and the urns weren't in there, so we're not gonna pay for those. Come on, really? You killed their children.
timeliness objection?
Oh gosh, so angry.
We did raise a timeliness objection in our pleading. I have thought about that and whether or not I think that it is a really valid argument to say that that's completely jurisdictional. I didn't to mean that the court can't take this under the review at this point in time. I didn't read the judgment language in in such a strict fashion that I felt like we could say 61 days means the court's not going to consider it at all. So it is past your 60-day deadline, but I don't know that that is completely jurisdictional in the way that you drafted your judgment.
Anything else?
No.
Thank you. Mr. Thompson, any rebuttal?
No, Your Honor. Thank you.
All
Ooh.
right, thank you. I'll take the matter under advisement. Issue.
So did you see that? She's like, "Ah, it's not within the 60 days, Judge." So, and the judge is like, okay. And so usually when you're winning an argument, you don't poke the bear. So in Thompson saying, "No, Your Honor, this is all I got," is a great move. Now we'll have to stay tuned to see what his judgment is going to be. I cannot sense that he is going to not rule in their favor. I mean, come on. You know, this man tortured and killed these 4 university students in their sleep in the early morning hours. Judge Hippler had some poignant things to say at the end of Kohberger's plea agreement. Again, we'll go over that at a later date. So I cannot imagine that Judge Hippler will not rule in the favor of the state and allow Mr. Kohberger to have to pay for these funeral costs. All right, so give me your comments and your thoughts in the comments below. Don't forget to like and subscribe this video for more content. Tomorrow is Friday. We're going to do Recap Friday on some of the cases that we're going to be covering for the future and maybe revisiting some things that have happened in the past, but you'll be super surprised to see what we're covering next. So thank you again for tuning in and watching. I hope to see you again soon. Bye.